Restitution?
Yes, Your Honor.
All right, where are we on restitution?
We have an agreement for $700 restitution, Judge.
All right, we're going to go on the record in cause number 2022 CR 6641, State of Texas versus Christopher Joe Medina. Can I have parties announced for the record for the state,
Hank Wilkins for the state.
for the defense?
Ruben Pisania for Mr. Medina.
And are you Mr. Medina?
Yes, ma'am.
All right, the court had in a supplemental report from probation that the restitution was to be $3,895.90. So what is the restitution amount?
Yes, Judge. So I have an estimate from Miracle Body and Paint for that amount. I reached out to Miracle Body and Paint. The person who did that estimate no longer works there.
Mhm.
So then I was trying to get a business records affidavit, but I would have to serve that on the defense for 14 days.
Mhm.
I was unable to get that done in time for this hearing today, Judge. We've reached out to the defendant at the last setting. She said she would be okay with the $700. So if the hearing has to be today, Judge, it would be for the $700, which we've discussed with defense. If we get some more time, we may be able to revisit that other number, Judge. I just didn't want to. I didn't think you did.
No, I mean, is it, if the agreement is the total amount of restitution that's owed is $700, is that what I'm hearing from both sides?
Yes, Judge.
All right.
Okay, pause right here. This is huge. The probation report said nearly $3,900. The prosecutor couldn't get the affidavit in time. And just like that, it drops to $700. That's not a small difference. That's a procedural fumble. And here's the lesson. In court, paperwork timing matters more than emotion. If you can't prove it properly, you can't collect it. Do you think that was fair or just a technical save?
Stamp, please. All right, the court is calling 2022 CR 7092, State of Texas versus Victoria Emily Cifuentes. Could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Cleophas Marshall or Miss Fuentes.
And are you Miss Cifuentes?
Yes, ma'am.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes.
Are you the same Victoria Emily Cifuentes who was placed on community supervision in 2022 CR 7092 for the offense of assault causing bodily injury on November 16, 2022 for a term of 1 year? Is that you?
Yes.
All right, state.
Violated condition number 4 in Bexar County, Texas. The defendant, Victoria Emily Cifuentes, then and there failed to report to the supervision officer as directed for the months of December 2022 and January 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 4, the court could grant the motion and sentence you to 1 year in the Bexar County jail? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Judge, it would be a 6-month extension for her to complete her to finish out probation.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Victoria Cifuentes.
Why are you not reporting?
There's really no.
Now this is where things shift emotionally. She pleads true. She could get a year in jail. But listen carefully. Homelessness, no support, sleeping on the street. This is the tension of probation court. Is this willful defiance or survival mode? And judges have to decide that in minutes. What would you do here? Punish or extend?
So do you have a place to live now?
Since April, I've been in this program. I've been living there, completing it and everything and taking me in. And I plan to continue staying there.
What program is this?
If I may, Your Honor?
Yes.
It is, Behold, I do a new thing ministries. And the pastor of that ministry is here with us today, Pastor Christine.
Okay.
Miss Fuentes was homeless as she stated she didn't have anywhere to go. So she was basically sleeping out on the street. She heard about this ministry. She went there in April. They brought her in and they have been counseling her and helping her to get back on her feet and to get in a good place. I'm very familiar with Pastor Christine. I've had other people there before. I had one young lady that was there who was on drugs really badly and didn't have a place to stay. They got her on her feet. She's employed now and doing very well. So I know that the program works. Ms. Fuentes has been in the program and she's been doing well. We would ask that she continue to remain in that program and possibly even do community service there if necessary. And we can speak to that in just a moment as far as community service, if the court agrees to extend her the 6 months as requested.
All right, this is what the court is going to do. The court will deny the motion, alter and amend conditions to include a 6 months extension, and you are to remain at the Behold, I'll do a New Things Ministries until further notice. If you wish to leave that location, you'll need the court's permission. Do you understand?
I do.
And you're going to have to need to continue to report. Do you understand?
Yes, ma'am.
All right.
Judge, the court, I believe, had stated if she were to get the COVID vaccine, that the court would reduce the community service hours by 40.
Yes.
And I think also, and I don't know for certain, but I think the court had stated something with regard to her doing a parenting class.
Yes.
That the community service hours may be waived. I'm not.
Yes.
sure about
Once
that.
she completed the parenting classes.
Okay, so.
And it was with Triple P.
Okay.
Have you started on parenting classes?
No, ma'am.
All right. Probation. She can do parenting classes with Triple P or Rainbows. Either one, whichever one you all feel is appropriate. All right. Is there anything else?
There's nothing else. Thank you, Judge.
All right. Thank you.
Do you, may I have that, might give the court that another copy of this?
Yes.
Go around the.
I don't know. She didn't give me permission. to
Go
come.
around.
Okay.
I don't know why it's so hard to go around. All right. Thank you.
Thank you, Judge.
Thank you.
You're welcome. Mental health court? Yes.
Yesterday, they were staffing it, but it's still pending approval according to probation.
So we got an indication from our chief that there had been an application for mental health pretrial diversion submitted. So we think there's some confusion. I don't.
That's the only way that they're going to take him.
Oh, if it's a pretrial diversion?
Yes.
Oh. Okay.
So what was agreed to was that we would do a referral for mental health court. If they accepted him, he can always come back and ask for a motion for new trial. I don't know if were the prosecutor took the plea or not,
Okay.
but it was agreed that if he were accepted, that's what the state would be in agreement to.
Okay. I think the prosecutor handling it was confused as to what that would entail.
Yes.
So if the court would give me a week to talk to my chief and kind of figure out what
Okay.
our position is.
All right. And so how much more time are they asking for as far as the evaluation?
Well, apparently we're just waiting for the chief's approval.
Okay. Can you recall this in 2 weeks? All right. We'll be back on August 24th.
Thank you, Your Honor.
Sure. The motion?
For our judge.
All right. Court is calling 2021 CR 2273. State of Texas versus Matthew Thomas Stribling. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
Defense?
David McLean from Matthew Stribling.
Are you Matthew Stribling?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt. Did you review that, Mr. Stribling, with your attorney? Did you understand it? Are you the same Matthew Thomas Stribling who was placed on deferred adjudication in 2021 CR 2273 for the offense of assault, family choking, strangulation on October 12th, 2021 for a term of 7 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor. In violation of condition number 41, on or about the 9th day of July, 2023 in Bexar County, Texas, the defendant, Matthew Thomas Stribling, then and there failed to comply with the rules and regulations of the felony drug court by blowing a 0.048 on his breath check device at 5:51 p.m. in violation of condition number 41.
How do you plead to that? True or not true?
True.
And Your Honor, we'll waive and abandon the remaining.
Any objection?
No objection, Judge.
All right, did you understand by pleading true to violation of condition number 41, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine.
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes, ma'am.
Court will find violation of condition number 41 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement, and I'm looking for the page here, is to deny the motion and to alter and amend conditions for state ISF for both tracks.
That's our understanding, Judge.
And probation, is that what you're requesting? All right. Mr. Stripling, I can do that, or either I can sentence you to prison for 3 years. Which would you prefer?
The state is
All right. Court will find it true, deny the motion, alter and amend conditions to include state ISF, cognitive, and substantive track. And then following a release, it'll be the UA hotline until further notice. Field visits will start off at 1 time per month for 4 months, and then after that, probation as you deem appropriate. Is there anything else from either side? All right, Mr. Stripling, you're gonna have to do better. You understand?
Yes, ma'am.
All right, good luck to you.
Do you know how long the program is?
All right, Mr. Longacre is here.
Yes,
Right. And are you Ms. Martinez?
Yes.
Any objections to Mr. Longacre appearing by video, state?
no, Your Honor.
Do you have any objection to your attorney appearing by video?
No.
All right, have both parties had a chance to review the PSI report, state,
Yes, Your Honor.
defense?
I have not, Judge. I have not seen it.
All right, so, Mr. Longacre, where are you located? Are you downtown?
No, I'm not. I'm at home ill.
All right, does somebody want to forward the PSI report to his email? If you could do that for me, please. Thank you. All right, just have a seat.
Thank you, Judge. I'll review it. I'll be right back.
All right, so this is the last one we're doing. Are you all ready to proceed?
Yes, we are, Your Honor.
Court is calling 2021 CR 8391, State of Texas versus Monica Reynolds. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense,
Garza Jr. for the defense here.
are you Monica Reynolds?
Yes, ma'am.
Going to show you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Monica Kayleen Reynolds who was placed on community supervision in 2021 CR 8391 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on February 28, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. Violated condition number 4 in Bear County, Texas, the defendant Monica Kayleen Reynolds did then and there failed to report to the supervision officer as directed for the months of April and May 2022 in violation of condition number 4.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violation conditions.
Any objections?
No objections. ma'am.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you to 4 years in prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, there is, Your Honor, and it is to revoke the individual off for probation, reform the underlying sentence to 2 years in the Texas Department of Corrections.
All right. Has she done anything on probation?
No, Judge, her probation actually started about 4 months ago.
Is that true? The probation started 4 months ago?
February 28th, 2022.
Started on February 28, 2022.
Oh, 22, I'm sorry.
Yes, so,
A year.
yeah, so,
I'm sorry.
A few months. Yeah.
all right. And you're taking something in consideration, state?
Yes, Your Honor. And, case number was CM
098.
967. That's a UUMB judge. And it was pending when she took this plea.
Okay.
So that's why the state is, I mean, it should have been taken care of at that point.
All right, the court will grant the motion. The court will revoke you, sentence you to 4 years in the prison, give you credit for any time served. Take in consideration 098967. Going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Excuse me, miss. Excuse me.
Yes, ma'am. Sorry.
Did you review that document with your attorney? Did you understand it and did you sign it?
Yes.
All right. Because this was not a plea bargain agreement, you do have a limited right to appeal, and that is as it relates to the allegations in the motion, not the fact that you are in community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Renee Gardea.
I'm sorry, who?
I've got Renee Gardea on the docket.
Mhm.
We had her examined her competency, and miraculously, she was able to answer the competency questions that she was seriously.
Okay. Yeah, you're whispering.
Well, I would like to see if I could get her screened for mental health pretrial diversion.
All right, if you have them pull the file.
Gardea, yeah. Renee Gardea, yeah.
All right, have her come up. All right, everyone needs to whisper. All right, state. This is Renee Gardea. And on this case, they're going to see if she can be screened for one of the courts, mental health court.
Yes, sir.
All right, how long do you all think that will take, the screening?
Trish is going to email me an application today, Judge, so we could get it started quickly. I think probably a 45 day reset would be enough to see if we get in.
All right, Ms. Ferguson, on this case, if you can give me a 3-week reset and we'll just see where we are. And if we're still in the process and it hasn't been done, just come before that time and let the court know and we'll reschedule her. All right, once you sign the reset form, you're excused. We'll be back on October 19th. Thank you. You're welcome. And are you ready on your case?
What?
Yes.
When we confer, there's nothing that we can do.
Okay. All right. Could I see the parties on Marlon Simeon? Bashan, on Simeon? So your client is on bond.
That's what I understand.
So he needs to be here for court. So what we're going to do is I'm going to recall it because maybe he didn't know. Norma, can we recall this for Tuesday? All right. So we're going to recall this for Tuesday. If he doesn't show, he may end up having a warrant. And he's on bond on this case, correct? Obviously, if he's out and
I
about.
gather, I don't know, I've had no contact with him. I don't even know anything about it. So I'll look into it. Is that the only possible court date? I mean, that doesn't, I need to kind of track him down.
Oh, if you call the bondsman, because he's on bond.
Yeah, but it's a federal bond. I don't know about.
No. He's on bond for this case. Is he on bond for this case?
I have no idea. I'll find.
All right, if you,
I'll check with Norma.
yes.
Looks like it's a man without one.
Okay, so somebody needs to check and see if he's at the Bear County Jail then.
Well, I called there like 2 weeks ago or a week ago and he wasn't there. So.
All right, well, if you call his officer in federal court, they'll probably have his contact information. So, Norma, let's recall this for Thursday. If he's not here on Thursday,
Okay.
we will have issues. All right, September, this is a motion to revoke. Mhm. Okay. Okay. Oh, no problem. Yes. All right, everyone, make sure you keep your voices down, please. Court is calling 2020 CR 2517, State of Texas versus Humberto Chavez. Can I have parties announced for the record for the state?
Jason Gearhan, Your Honor.
Defense?
Adrian Pettis.
And are you Mr. Chavez?
And Your Honor.
All right, I'm showing you what's entitled Motion to Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor, I did.
Are you the same Humberto Chavez who was placed on community supervision in 2022 CR 2517 for the offense of possession of a controlled substance, penalty group 1 less than? All right, does anyone want to make a oral motion to the motion to revoke?
Yes, Your Honor, oral motion to change the verbiage states possession of controlled substance penalty group 1 less than 1. It says group, we're asking for less than 1 gram. No objections.
All right. So are you the same? Are you the same Humberto Chavez who was placed on community supervision in 2022 CR 2517 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram on June 6, 2023 for a term of 3 years? Is that you?
Yes, Your Honor, it is.
All right, state.
Yes, Your Honor. Violated condition number 1, on or about the 25th day of August 2023 in Bexar County, Texas. The defendant, Humberto Chavez, committed the offense of evade, arrest, or detention in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor. Your Honor, we'll waive the remaining violated conditions.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to $1,000 fine?
I understand, Your Honor.
I'm sorry, everyone, just one moment. Can you mute us, please? I'm sorry about that. It's usually those are medical appointments, so I need to answer them because they're medical appointments for people in my family, okay? All right, so did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, sentence you up to 2 years in the state jail facility and up to $1,000 fine?
I understand, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there an agreement?
There is, Your Honor.
And what is the agreement?
The agreement is to adjudicate guilt, to revoke the individual office probation, sentence him to 180 days in the Bexar County, I'm sorry, not the Bexar County, the state jail facility. And also the state will take into consideration the 2 new number 1s, false numbers 715.
Everyone, please whisper.
715-748 and 715-749.
All right, is that the agreement?
Yes, Your Honor.
Mr. Chavez, are you asking the court to follow that agreement?
I am, Your Honor.
Are you waiving your right to appeal?
I am, Your Honor.
All right, the court will follow your agreement, sentence you to 1 year in the state jail facility, give you credit for any time served, take in consideration 715-748 and 715-749.
Your Honor, our agreement was for 180 days.
Oh, I'm so sorry.
That is.
Yeah, I was just seeing if people.
Did you catch that? The judge says 1 year. Everyone freezes. Then she laughs and says she was just checking if people were paying attention. That moment tells you something important. Courtrooms are intense, but experienced judges sometimes use humor to control the room. Still, imagine being the defendant hearing 1 year before the punchline. Heart rate through the roof.
However, if you were placed in the therapeutic community, it will not extend your 180 days. So would you prefer that or no?
No, Your Honor, actually, I think I could just be done with.
All right. So here's the thing. If you don't get your life together, you're going to be back right here with another drug case. Do you understand?
I understand, Your Honor.
All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
I did, Your Honor.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I do, Your Honor.
All right, we can go off the record. Mr. Chavez, I remember you, and I will tell you what is happening with your face. That has gotten bigger than it was the last time you were here. You need to go see a doctor and have that looked at. You understand?
Yes, Your Honor.
All right, good luck to you.
God bless you. Thank you.
All right, thank you.
Thank you, Your Honor.
You're welcome. Elsa Morales.
You see the fifth page of life of probation. There's one letter of support. I would like to submit support from her daughter.
Okay. All right, who is the prosecutor on this case? They know. Yeah. All right, court is calling 2023 CR 5382B. I'm sorry, what? Hi. There's a lot happening. So everyone, this is what we're going to do. When we're on the record, don't approach the court coordinator because they're too close. If you want to approach the deputy and have them bring your person out, you're more than welcome to do so. Court is calling 2023 CR 5382B, State of Texas versus Elsa Morales. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Glenn Payne for defense.
And are you Miss Morales?
Yes, Your Honor.
All right, you entered a plea on August 14th. You entered a plea of guilty, applied for deferred adjudication. The state is asking that your punishment be assessed at 1 year in the state jail facility. They're remaining silent on your recommendations and they're taking certain cases into consideration. Have both parties had a chance to review the PSI report?
Yeah, there actually wasn't a PSI created in this court. You asked to reset. We asked for the PSI to get the letter, then you just wanted to see the criminal history.
Yes. So is there criminal history available for the court? All right, the court has reviewed the criminal history. Defense, do you have any witnesses?
Judge, no witnesses. Like I said, we just had one support letter on behalf of Ms. Morales. It's her daughter, stating how she helped, that Ms. Morales helps take care of children, and she was working at a home health care, also supplied money for the family. We're gonna ask that the court grant her probation in this case, and let her continue to support her family.
All right, Ms. Morales, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Elsa Mireles.
All right, why are you stealing?
That was a bad choice. I wasn't thinking.
Why are you involving a child in theft? Because it says that this was the MO, go to the store, put things in a cart, and then have a child push the cart outside. So you're basically unwittingly making a child a criminal. Why are you doing that? I mean, your attorney was not there, so he can't answer this question. You did it. You took a child in Target, or as we say, Target. You took a child there, loaded things in a basket, and for that child to know to just push that cart towards all points of sale tells me that somebody told that child, this is what's going to go down. We're going to go in, we're going to put items in this cart, and you just keep pushing it. So why?
I have no words for that.
Yes. And how old was the child that you all involved in your criminal activity who now thinks it's okay to engage in criminal activity?
5 years old.
All right. So you took a 5-year-old. And what day of the week was this? Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, what day?
I'm not sure.
All right. Was it a school day?
No, I'm not too sure.
All right. So you take this 5-year-old, walk me through it. So the 5-year-old is pushing the cart out and obviously police are called, right?
Right.
And did they speak to the 5-year-old? What is the 5-year-old thinking? Do you know? I know somebody will probably object to speculation, but I just want to know, what was the 5-year-old doing when police are there? I'm assuming you all were placed in handcuffs.
I was already in the car. It was with his mother.
Mhm. All right. So it was you and his mother who was stealing. Is that what you're saying?
We were already out and the mom told him to leave it there and he did it.
I'm sorry, I can't hear you.
Somebody else helped the little boy push it out.
All right. So someone helped the little boy push the cart out after you all were committing a theft from Target. And what items were you all taking?
It was stuff for the kids.
No. Don't put this on the children. What items were you taking?
Toys.
And what else?
It was clothing.
So you're teaching children that in order to get things, they should steal. That's what you're teaching. And you left out to the tune of $553.69. So how full was the cart that you were taking out?
It was full.
All right. And then now I've received this letter where you took a child to help you steal, and somebody is saying that you're taking care of children and you're a home health care provider. I don't allow people in this courtroom who are on probation to be home health care providers. And who are you providing health to? Is this a relative?
No.
Right. So I don't know how you're able to take care of children and be a home health care provider.
Those are my kids that I take care of.
Mhm. I don't think you're a good candidate for probation because it appears that your background is littered with theft cases and you're here on a theft enhanced. And how old are you?
43.
I mean, you're old enough to know better. It's not like you're 20 or you're 19 and you have peer pressure. So again, tell me, why are you stealing? It says here that you have a job, that you can pay for things. I don't understand the stealing.
Your Honor, but that doesn't excuse for it.
I'm sorry, what?
I didn't have a job at that time, but that doesn't excuse. For it.
And it certainly doesn't excuse involving a 5-year-old in your criminal activity. So again, why should I give you probation? The state is silent. Why should I give you probation?
Because I gotta take care of my kids. There's no fathers involved for my children.
Well, when you were using the 5-year-old to steal items, were you thinking about, who's going to take care of my children if I am at the Bexar County Jail? Were you thinking about that?
No, Your Honor.
And if something would have ended up happening, sometimes when people go to places and they steal, sometimes people end up getting shot. If that 5-year-old would have been shot, you know what would have ended up happening?
This is the turning point of the entire hearing. The judge isn't just talking about theft anymore. She's talking about consequences. When she says, if that 5-year-old had been shot, that's strategic judicial framing. She's forcing the defendant and everyone watching to confront the worst case outcome. This isn't about $553 in merchandise. It's about putting a child in danger during a crime. That's why the tone just shifted from probation discussion to prison.
Now, mind you, name them all because I've read the report.
Like, I believe 5 cases.
And you have not learned anything from that. What you've learned, obviously, is to continue to steal and start this idea where you take a child in with you, you put items in a cart and you just have them pushing it out. In my mind, I can imagine this 5-year-old, because when you see children pushing carts, they're not even old enough to stand and look over the cart. They're just struggling, barely pushing it. And I'm always thinking to myself, why doesn't a parent help that child push their cart?
Your Honor, we told him to leave it there and he continued pushing it out. That's when the other 2 people helped him.
Oh, so now you're saying
Yeah, that's what we did.
you did not include him in your criminal enterprise.
We told him to leave it there and the other 2 people, random people, helped him.
Oh, so this is not a theft case. You were not intending to have him steal. Is that what you're telling the court?
That's what happened.
No. Are you telling the court that this was not a criminal enterprise, that you or somebody loaded a cart at Target with items, the 5-year-old was pushing it, and you're continuing putting items in a cart totaling over $500, and then as he's pushing the cart past points of sale, you're telling him, oh, just leave that there. Maybe you're telling him, we don't have money for that. We just loaded up the cart for some unknown reason and we have no money for that. Is that what you're telling the court? If not, let me know. I mean, I wasn't there. State wasn't there. Your counsel wasn't there. I'm just trying to figure out if that's what you're telling me. If that's not what you're telling me, say, Judge, no, that's not what I'm telling you. I'm not going to take that as a sign of disrespect. Okay. So are you telling the court that you all loaded up a cart of items at Target? The 5-year-old is pushing the cart and you're telling the 5-year-old, leave the cart there, we don't have any money for these items, and your intent was just to walk out. Is that what you're telling the court?
To walk out without the stuff, like to leave the stuff there.
Okay. Is there anything else?
Judge, with this testimony elicited from my client at this time, I think we need to ask the court to withdraw her plea.
All right, that'll be denied. All right, this is what the court is going to do. Court is going to find you guilty. Court is going to sentence you to 1 year in the state jail facility. Give you credit for any time served. Take in consideration GJ 812055, JN number 2127782. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Good luck to you. Do not steal. Competency being coded incorrectly. Where are we?
He still has not been evaluated by the doctor. We don't have a report. He's obviously on bond, Your Honor, and is just waiting for, I got with the magistrate court after the last court setting. They said that a doctor or somebody would reach out to him. They have good contact information for him. They have his phone number as well as his stepmom's phone number.
All right, this is what we're going to do. We're going to reset this for 45 days. And once you get your reset form, counsel, if you could take him to the magistrate court and find out what's going on down there.
Sure.
And make sure that the court coordinator has his contact information. And then if they give you a date certain, if you'll come up and let the court know, and we'll change this date. Ms. Ferguson, I need a 45-day reset on Shane Riley. All right, so we'll come back on November 9th.
Thank you, Your Honor.
All right, thank you. Thank you for your patience.
Would you like the defendant?
Yes, please. It's always great seeing you. I love the pen.
Good morning.
All right, so in this case, DNA.
And so just to give the court a status at the last setting, the DNA evidence finally came in. I have hired a DNA expert. I immediately sent that information to him. I have not yet gotten a report back from him. I would assume to get something back from him within the next 30 days. And so we're here asking the court for a 30-day reset.
All right, Ms. Ferguson. On this case, give me a 45-day reset on Carranza. All right, it's going to be November 9th.
Okay.
So at that time, state, you need to be prepared to tender an offer, and then it's going to be a quick turnaround for a plea deadline date.
Thank you, Judge.
All right, is there anything else?
There is not. May we be excused?
Yes.
Thank you.
All right, as soon as no Spanish interpreter needed. Thank you. Jonathan Oleg.
Coming up to.
All right, we're here for discovery. Where are we on the discovery?
I believe discovery is complete, Your Honor. We'll send her a discovery receipt.
And are you prepared to make an offer today?
We did make an offer, Your Honor. I believe counsel has given that offer to his client and had time for his client to.
All right, Ms. Ferguson, on this case, if we can recall it in 2 weeks for a plea deadline date, please. All right, so we're going to come back on October 12th. All right, thank you. So where are we on this case?
Well, first, we don't.
And here we go, the YouTube moment. Defense says they don't consent to appearing online. Judge, motion denied. This raises a fascinating issue. Courtrooms are public record. Transparency is the rule. But in the digital era, public record now means viral exposure. Should court proceedings be streamed like this? Or does it create collateral damage outside the courtroom? Curious what you think.
Discovery was provided to defense. They provided it electronically. We sent the link to files, I'd say a few weeks ago. Defense has access to those files through those links for about a year.
All right. So is there any other outstanding discovery?
Defense did bring to my attention through email earlier this morning, 2 or 3 items that I did not have the chance to fully check the electronic discovery to see if they were in there. It's statements from witnesses that were taken at the scene. There's a lot of discovery here, so I couldn't say whether or not we've already provided it. But if I get a short amount of time, I couldn't verify that.
All right, Ms. Ferguson, on this case, give me a 30-day reset for discovery, please. This will be the final discovery date, and we'll hear motions on that date.
Your Honor, there's also a outstanding motion to modify conditions of bond. Ms. Schnitz, and this is one of the reasons we don't want to be appearing on YouTube. Ms. Schnitz has been ordered by the court not to drive. She has a vehicle in her driveway that is being in the process of being repossessed. Obviously, these are very personal matters. She's also in a child custody dispute with the father of her children. And he is using these videos in her.
All right, Ms. Ferguson, can I have a 30-day reset? At that time, the court will hear your motions. And at that time, that's the last time the court will have this set for any outstanding discovery. So you all need to confer and you all need to make sure that you have all of your discovery.
Yes, Judge.
Can we get the ignition interlock device removed from her vehicle?
I will have the discovery hearing and I will have the motions hearing in 30 days. Everybody needs to be prepared for motions.
And if the car gets repossessed before then, Judge?
All right. What date, Ms. Ferguson? All right, October 26th. All right, and the state was to provide an offer. Have you received an offer?
No, Your Honor.
Did you confer with the state today?
Yes, Your Honor.
Yeah, I think what the problem is that the file right now is missing. We don't look at the docket necessarily, but we are in the process of looking for that. It's going to be obtained. I've had several people go look for it right now, Judge. If we get a little bit more time.
Sure. All right, just have a seat. We'll call you up.
Your Honor, I have a civil district court presiding case that we've announced 3 to 4 hours over there. Can I get the excuse to go over there with, and I'll give Mr. Garahan my cell number and he can text me if it's available.
All right, and you need to come back and criminal district court takes precedent, but I'll let you go over there.
Thank you, Your Honor.
You're welcome. Issues. Where are we on discovery?
I believe we turned over some discovery this morning. I know that Mrs. J was in trial when we were in trial and it was supposed to be exchanged in, but I think we cleared it up if I'm correct.
Yes, Your Honor. It was a misunderstanding, but I do have everything to say.
Okay.
So I think our minds were on, both of us were on different things, but we have it today. And that should be the only discovery that is outstanding.
All right. And so state, were you prepared to make an offer today or no?
We can. I don't know if one has been given or not, but I can give an offer today. If she can. Yes.
All right. So
I'm not prepared to counter it. I have to look at the surveillance video related to this robbery.
all right.
That's what's turned over today.
All right. So Ms. Ferguson,
Yes, ma'am.
and state if you'll give an offer today. And Ms. Ferguson, if you'll give me a 30-day reset and counsel, that will be your plea deadline date and you all can confer off docket. Is that enough time for everyone?
I think so, Your Honor.
All right. All right. October 26th. Is that good for you, Ms. Gay?
Yes, it is.
All right. We'll see you back on October 26th.
Thank you.
You're welcome. All right, Mr. Armstrong. Why were you late? No, he was late. Because I called the name and I put NP for not present.
He would have been outside in the hall, Judge. He was here 2 days ago for 3 hours, and I don't anticipate that it was anything intentional. I think he may have just been outside because he was texting me this morning while I was on a Zoom hearing. So apologies.
Okay. So we're here for a motion to revoke.
Yes, Your Honor.
Are both parties ready?
Yes, Your Honor.
Court is calling 2022 CR 0686, State of Texas versus John Carlo Cisneros Armstrong. Could I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
And Brian
Defense.
Powers for Mr. Armstrong, Your Honor.
And are you John Carlos Cisneros Armstrong?
Yes, Your Honor.
All right, you were placed on deferred adjudication in 2022 CR 0686 for the offense of aggravated sexual assault on June 14th, 2022 for a term of 8 years. Is that you?
Yes, Your Honor.
State? Oh, I'm sorry. Off the record. This was reduced to attempted and it's not listed in the motion to revoke as attempted.
And we will stipulate to the attempted, Your Honor.
All right, so I will reread. How do you plead to that? True or not true?
Sure. Violated condition number one, on or about the 12th day of August 2023 in Bear County, Texas, the defendant, John Carlos Cisnero Armstrong, committed the offense of failure to identify in violation of condition number one.
How do you plead to that? True or not true?
True, Your Honor.
And Your Honor, we've waived the other violations alleged in the motions.
All right, any objections to the waiver?
No, Your Honor.
Did you understand by pleading true to violation of conditions 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations, conditions 1 and 1?
Yes, Your Honor.
Court will find violations 1 and 1 true. Is there an agreement?
There is, Your Honor, the defendant has agreed to state ISF, Judge.
Okay.
And that is the agreement, Your Honor.
Is this just state IS cognitive?
It is, Judge. We checked a couple of days ago, I believe it would be a 40-day wait inpatient and I believe a 90-day inpatient after that. So he's aware that he's looking at a commitment of 130 days.
All right. And is he eligible for state ISF?
Your Honor, he will be, I forgot to mention, he pled true to these two violations. With the state is going to TIC the underlying.
All right. And what are the cause numbers? You can talk.
I've got them for you, Hank.
Oh, thanks.
Your Honor, one of them is 714734.
Mhm.
The other one is 714735. They were both out of the same incident.
All right. The court will find violations of 1 and 1 true. Probation, are you in agreement with this recommendation? Yes. All right. The court will deny the motion, alter and amend conditions to include state ISF cognitive, take in consideration 714734 and 714735. Mr. Armstrong, is there anything else you need from the court so you can obey the rules and be a productive citizen?
May I speak on his behalf, Your Honor?
No, I want to know if there's anything else he needs.
Oh, yeah, there's one thing, Your Honor. It's just if I may be able to attend church again.
Oh, no, we're not even at that point. We're at the point where you're on deferred adjudication. You're looking at 20 years in prison and you picked up 2 number ones. So what I'm trying to figure out is what is your thought process that you're not thinking and it's not at the forefront of your mind that you could be doing 20 years in prison? I'm sure your attorney has spoken to you about this. I don't take any joy or pleasure in sending people to prison. When I place people on probation, I'm hoping that they're going to be successful. I want them to be successful. I want them to turn their life around. I don't want them to come back before me unless they're coming back before me to say, I've learned a lot. You'll never see me again for this. You understand?
Yes, Your Honor.
So I'm talking about in terms of that. Is there anything else you need from the court?
No, Your Honor.
All right, then I'll sentence you to state ISF cognitive, taking consideration 714734 and 714735. Once you're released from state ISF, you need to immediately contact your probation officer. Do you understand?
Yes, Your Honor.
All right, we can go off the record from here on out. Everything that you do, you need to ask yourself 2 questions. 1, is this something that could potentially result in me going to prison for 20 years? If the answer is yes, don't do it.
This right here, that's the line of the day. If the answer is yes, don't do it. If it's maybe, don't do it. That's not just advice for someone on deferred adjudication facing 20 years. That's life advice. This judge isn't yelling. She's not threatening. She's drawing a very clear line. You are out of second chances. And in probation court, that line matters.
Raymond and Victoria got off the case.
No, what I'm saying, he has immigration issues.
I'm perfectly capable of dealing with his immigration issues, but I will get with whoever they.
Well, my understanding, she's already done a report. I'm just giving you an update.
Oh, okay. I got you.
So that was done in February. This case has been lingering since January. So, and I know you were recently appointed, so I'm going to give you a chance to get caught up on discovery if you need a chance for that.
Please, and I did confer with the state. There is evidently a massive amount of discovery that I'm going to try to get from Raymond because they gave him a hard drive, or I guess one of those terabyte hard drives that he got everything on. So I'll get with him, see if he'll go ahead and just give that to me and I'll trade him a blank one for it. I know that they are also transcribing interviews. So that's something that the prosecutor let me know that they are still working on, that has not been completed yet. But I'm just going to get caught up, Judge. I will let the court know that I have a quote unquote vacation coming up because I'm going to be in Comal County in a capital murder case for a couple of weeks. Great vacation.
All right. When is that?
That October, it's going to begin October 6th and it may run into the second week. They do things very differently from here. So their trial is every day, all day. So,
Okay. All right, Ms. Ferguson, on Eric Gonzalez Lopez, recall this for 60 days.
And Judge, I did inform defense if they were unable to get the discovery through prior defense counsel that we can make arrangements for them to drop off.
Yeah.
All right, so that needs to be done
Absolutely.
before next week is concluded.
I'll either get it from Raymond or I'll drop off a hard drive of my own.
All right, what date? All right, November 13th.
Thank you, Judge.
You're welcome. And if you'll let your client know, please.